An executor is a person that you choose to administer your estate when you have died. They are your legal personal representative, so essentially they step into your shoes and they deal with your estate as though they owned it for that period of time that they are administering the estate.
So an executor is someone that you appoint under your will, whose their job is basically to take in all of your assets and then distribute them out to pay for any debts that are owing to your estate, and then pay them out to any of your beneficiaries as well.
So it's definitely not necessarily an honour or a privilege to be an executor. There is a little bit of work that's associated with being an executor, and you should choose carefully who you appoint. Lots of people appoint their spouse in the first instance, which I think makes a lot of sense, because who better would know you than your spouse? But otherwise, you should just be making sure that you're selecting somebody that's up for the job. They know what they're doing. You feel that they're comfortable and they'll be able to take it on. They've got the time and the energy to do it. And if you don't really have anyone like that in your life, then you might consider looking into appointing a professional instead.
A professional executor usually is a lawyer. They may be the person that made the will, or they may not be, or helped you make the will, I should say. They are paid to do the job. The benefit of having an independent professional executor is that they're uninvolved, they're dispassionate. People often choose them if they've got either a young family that's inexperienced, or if they've got a family that's going to quarrel, or they sense that there is a challenge on the way, some sort of family provision claim, or a claim that the will is not valid, some sort of dispute ahead. Then they will look to a professional executor who has experience, and in the case of lawyers, professional indemnity insurance to back up what they do.
The big benefit to having a professional advisor as an executor is that they are impartial and independent. So often people who might have a difficult estate for various reasons, like their estate is complicated, or they might have beneficiaries that don't get along, or perhaps somebody that was expecting to receive something from the estate has been left out. The professional executor will be able to manage that and apply a little bit of impartiality to what could otherwise be quite a contested and contentious scenario.
Even if you don't have a professional executor, you can still have either direction in your will that you want your executors to consult with someone, or even if there's nothing in your will, your executors are still perfectly able to reach out for assistance from accountants, financial advisors, lawyers, and the like. You don't necessarily have to have more than one executor. Typically, spouses will appoint each other in the first instance, and then maybe for this, any backups, they might have additional people. Depending on the circumstances, you might want to have more than one executor. Regardless, would always recommend that you have a backup executor in place.
We generally recommend having at least one backup executor. In terms of having your first appointed executors, you don't have to have more than one. You can really have as many as you like. But to keep in mind, one thing that we always tell people is that too many cooks can spoil the broth. So it can become more complicated the more people you add in. So 1 to 2, maybe up to 3 can be a good idea. But always think about having a backup, because that will save you some trouble and heartache in the long run if perhaps the first person's not able to act.
A beneficiary is somebody who will be receiving the assets or the gifts under the will.
So beneficiaries have certain rights from once you've passed away. These can include things like requesting a copy of the will. They can also be, they can contest the will as well if they don't feel that they've been sufficiently provided for underneath the will. And they're also obviously entitled to receive whatever has been directed in the will as well.
They have the right to information, so from the executor and from anybody else that might be involved in administering the estate, and the right to contest the will should the will not be as expected or what's intended. It's really important to keep in mind that the rights of beneficiaries are different across all the different states and territories. So if there is somebody that's a beneficiary of a will that is not sure about their entitlement or their rights, they should definitely seek legal advice in the appropriate jurisdiction.
When it comes to gifting your estate, what you can do is specific gifts, and these might be things like, a family heirloom or a specific piece of jewellery or a car that you want to go to someone. You can also gift things either outright or in a testamentary trust.
The first way is called outright gifting, which is the way to outright gift is to just direct an asset or part of an estate to a beneficiary, and then that becomes their personal asset, so it immediately just goes straight to them, no strings attached. The other way is to gift through a testamentary trust, which is a protected structure that gets set up under a trust to hold a beneficiary's interest or their gift under the estate on behalf of them.
An outright gift can leave the gift exposed, if you like, or vulnerable to third-party claims. Any one of us, if we are involved in an accident, can have a claim made against us, and the person making that claim has access to all of our personal assets. If, on the other hand, those assets are held separately from the individual, for example in a trust, those assets are protected from a third-party claim in most instances.
Gifting something outright basically means that the beneficiary, the person who's receiving it, owns it fully in their own name. And this might be appropriate in some circumstances. In others, it might not be, because there's certain risks that are involved with owning things in your own name.
So a testamentary trust is of benefit for anybody that is concerned about protecting their beneficiaries or the assets in their estate. So the way a testamentary trust works, it's like bubble wrapping a beneficiary's inheritance. So it's a trust that's set up in a will. You can only set one up under a will. The will has to specify that there's a testamentary trust for a beneficiary. And by doing so, the person that's made the will can apply different levers of control over the testamentary trust. So that might be something like appointing somebody else to control the trust, so a co-trustee or a protector of the trust, until the beneficiary reaches a certain age. Or perhaps there might be a controlled release of assets from the trust. So perhaps there's a controlled person looking after the trust until a beneficiary reaches 30 and then 35 and then 40, something like that. So the benefit is that you really do have a lot more control and protection in the testamentary trust scenario. And it's a really good way to protect either very young beneficiaries or people that have vulnerabilities or might be under a legal disability.
Any trust or any discretionary trust, the trustee of the trust has a range of beneficiaries to whom they can give income of the trust to, and they might do that based on the tax position of the various beneficiaries. There might be an advantageous way to give the money from a tax point of view. If the child, or if there's a beneficiary who is a minor, there are some advantages in that they receive, say, close to $20,000 tax-free from the testamentary trust for certain purposes, and this is different from other trusts.
If you have assets outside of Australia, it can be a bit more complicated. We typically recommend people seek advice from a lawyer in that specific country. This is just because not every country will recognise an Australian will, and it can make things a lot more complicated down the line.
Some countries don't even let you make a will. You just have to distribute your estate in accordance with the legislation there.
You can nominate a guardian in your will, and usually that will be the person that receives care of your children. If you don't do that, your family has to appeal to the court for custodial rights.
That person will assume responsibility for your children in accordance with your will, and sometimes the will might dictate other things about how the children are to be cared for. So the parents might include things about where the children should live, how the children's expenses should be paid for, anything else that might be relevant to their specific scenario.